So this is a great month for law geeks, and I am a law geek through and through. And it is that because this is the month the Supreme Court issues opinions and sets up its docket for next term. So they're doing these two things that I am just absolutely in love with. And I'm that guy that in May and June is sleepless every Monday night because I know Tuesday mornings I'm going to get rulings from the Supreme Court. So I rush in the morning, I turn on, you'll see on my PowerPoint in a minute. Don't put it on yet though. The place I go so I can see this live feed. This is the best time of the year. Well, maybe I should back up and say, apart from my beloved Green Bay Packers, and I feel like I have to say that out loud with my friend Bill here, the Supreme Court's my second favorite thing on earth. So, back to them issuing opinions and granting cert in new cases. They have been historically slow this year, and some of you probably know this if you've been watching the news at all. The number of cases decided at this point is as low as it has ever been at this point in the year. The number of new grants is as low as it has ever been at this point in the year. There's a lot of conversation about why that might be. There's some speculation that there's some tension on the court. And in one of the cases I'm going to mention later, that sort of bubbled over between Ruth Bader Ginsburg and Neil Gorsuch. But they've done a lot of really interesting and a lot of real good things so far this year, and we'll talk a bit more about that in a minute. We're still waiting on the Big Five Masterpiece, which is the case in which the court's going to decide whether or not a state can tell a private business that they must serve somebody who would like a service relative to a same-sex marriage. It's a fascinating rights and conscience case, probably late this month. The second really big ticket case that's still not in front of decided is Carpenter. This is a great case that asks whether or not police can monitor where you are by looking at where your phone is without a warrant. The third of the Big Five is Gill. This is a gerrymandering case. Is the court going to undo some of what we've done? And I think here, as Bill talks about undoing democracy, one of the ways we've done it is to gerrymander ourselves into a position where very few politicians run in contested districts anymore. The fourth of the Big Five cases is called Janus, and this is one that asks whether or not somebody who chooses not to join a public sector union can be compelled to pay an agency fee, even though he's paying it to a union that may say things, believe things, and actually in some ways put words in his mouth that he doesn't support. And the fifth of the Big Five that's coming, if none of those interested you, this one will because it hits your pocketbook, is Wayfair. And in this case, the court's going to decide whether or not states can compel online sellers to collect sales tax for them on all sales in every of the 50 states. It actually turns out that there's something like 7,500 taxing units in America. No surprise to you who know something about this. So the idea of saying to a small internet business, you've got to collect taxes for 75 different entities is just absolutely shocking. But the court's going to decide that one. So we'll come back to some of the ones that they have decided in a second, but let me come to my topic and my PowerPoint slide. Ready? Huh? I'm with NASA, which determined that PowerPoint makes you dumb. I mean this seriously. You might know that they looked very hard after the Challenger accident into all of the things that caused it, and one of which was lots and lots of NASA engineers made presentations filled with PowerPoint slides that absolutely nobody listened to. So I'm going to just give you one with my topic. My beloved Supreme Court rocks, and then I'm going to tell you everything you might want to know about what they're doing happens here. So if you, like me, turn out to be a law geek and want to get up Tuesday morning and watch the live feed as the opinions come down and lawyers type what they think about it, that's where to go to do that. So you'll see that. Now, let me turn more seriously to my topic. I think the Supreme Court is at once the least and the most democratic branch of our government. And I'd make a second argument, and it dovetails in a way that I'm just so delighted with. I didn't know what Bill was going to talk about other than his topic, or I should say his title this morning. And that is, I think it might be the most important branch of our government as we think about the erosion of some of the democratic values that we all hold so dear. So let me start by talking about what do I mean by democratic, and that might sound like, well, of course, we all agree about that. I'm not sure we do, because part of what I want to argue in terms of least and most important turns on what I think democratic institutions do. So I think you all know that this is this wonderful mashup of two Greek words, right? The demos, the people, and kratia, the rule. So democracy, the rule of the people, but that's way too simple. Or all we do is electronic plebiscites for everything we want to know. We just simply vote online. And I don't think any of us, at least since Ross Perot, if anybody remembers that name, thinks that's a good idea. I think a democracy is, and I should have put this on a slide, an ordered civil society that promotes individual liberty. And I mean not just tolerates individual liberty, not just respects individual liberty, but honest to God, genuinely promotes individual liberty and the rights that go with it. In fact, ultimately, I think democracy is about creating conditions for human flourishing. And one of the reasons I want to argue the Supreme Court is so essential for doing that is Congress doesn't care if you flourish, I don't think. The president doesn't care if you flourish. But in a lot of ways, the Supreme Court has put together the framework in which you can do that. So we're not talking about democracy that's just the rule of the voting majority. We're talking about a system of government that produces all of our capacity to flourish as human beings. And I want to make the case that the Supreme Court is deeply democratic if that's what we agree democracy is. So, the Supreme Court on paper, and I hold here my beloved Constitution, that piece of paper which in fact describes the Supreme Court, is, I think you'd agree, the least democratic of the three. I should just pause and say that any student coming to my office and asking me a legal question or making a legal argument leaves with a copy of my beloved Constitution. So please come by and do that. These are people that aren't elected, they're appointed. They serve life terms. And for many of them, I should say, have life tenure, and most of them serve very long terms. They are almost completely opaque in the way they do business. I'll wager none of you know how many of them have to vote to grant cert in a case. You probably have no idea what happens after they hear argument. And I don't say that to say, wow, aren't you not very smart? I say it to say they do these things in that way intentionally, secretly, and out of the public eye. And in a minute, I want to talk about why that might be. They don't have to hear your case. Indeed, they get about 7,000 requests a year, and they're down to making about 75 decisions a year. So they're hearing a tiny fraction of the number of cases that they could hear. They don't tell you why they don't hear their case. Those justices are there forever. You don't elect them. And you're probably saying to yourself, well, what in the world is Cavenagh saying? How in the world can that be a Democratic branch? So we'd go on. It's also the branch that's furthest from the news. You hear about the president, and indeed he makes you hear about him every day by saying something via Twitter. Yet another way me and my great friend Bill are different. I can't find it on the internet or my phone and never will probably use it. So you can say the most horrifying things about me on it right now while I'm talking, and I'll never know unless Bill tells me. But they're far from the news. The justices don't generally give interviews. Ask yourself when the last time you saw 60 Minutes interviewing a Supreme Court justice was. Almost never. They stay away from public writings other than their opinions. They don't talk about political issues out in the public. I'm a little nervous, I have to tell you, about this Ruth Bader Ginsburg movie that's out, because in some ways it breaks from a pattern of the Supreme Court saying we're not going to be part of that routine part of political American life. Third, you might even say to me, Cavenagh, you think this thing is so democratic, then why is it Article 3 of the Constitution? We've relegated the court behind Article 1, Congress, that thing that's so close to all of you. Indeed, behind Article 2, the presidency, all the way back there with least position of places, the Supreme Court. But I think these are exactly the reason why the Supreme Court is so profoundly important and so profoundly democratic, and in some ways so much a bulwark against precisely the kinds of things Bill worried. That justices are appointed, that they are confirmed, that they have life tenure, that they operate in opaque ways, that they operate totally outside of the news. This keeps them from the sort of pressures that corrupt the elected branches. And consider that in this country, which is right now so profoundly divided emotionally, politically, and I'd argue most importantly geographically, because we've carved ourselves up, some parts intentionally and in some ways with gerrymandering, into one-party districts. Everybody agrees with the people they live with, And almost everybody agrees with the people that they vote with. Here you don't have justices running for office in a one-party packed judicial district. And just think one little bit further. The court doesn't run for office, so campaign money doesn't matter to them. In fact, you can make a case that there's been less than 5 significant Supreme Court scandals in American history. We've had 5 this year in Congress, and we're only 5 months in. Keeping money, keeping the need to be elected and those sorts of things out of the court's worries puts them in a position where they can do some really important things. So what's this separation from partisan politics produce? Well, I think it produces a court that can and does vindicate and protect individual rights. And in fact, individual rights that are really unpopular. And I want to mention 3 cases on that in a moment. I've said that I think it provides them with an opportunity to be a bulwark against an imperial presidency. And whoever our president is, I think you can make the case over the last 3 or 4 that the powers of the president, at least the ones they're exercising, have been much more aggressively pushed at us. The Supreme Court's the check against that. Indeed, one of the cases that's coming towards the end of this year will be Trump versus Hawaii, and the question of whether or not the immigrant ban was constitutional. It's the court that stands between you and those things. So 3 examples from history: Brown versus Board, Loving, and Obergefell. All of these were cases in which an anti-majoritarian court, a court that said to the regular Americans, most of whom disagreed with them, we're going one way because it's constitutional, whether or not you people are going another. And that may sound anti-democratic, and I just want to tease out those cases in a second, but I want to argue that anti-majoritarian is pro-democracy if we mean that it advances human flourishing. So everybody knows Brown versus Board. This is the Supreme Court's decision that desegregated our schools. It's one of those places, and they are relatively rare, where the Supreme Court overtly and outright reverses itself. In that case, it overturned Plessy versus Ferguson, which said separate but equal is just fine. And indeed, one of the things many people don't know is that Thurgood Marshall, who was not yet on the court, but the advocate for the NAACP, was originally asked by the NAACP, argue separate but equal, but tell the court what you want is true equality, because it'll bankrupt the system and push them in a direction of doing something different. And really one of the great things about Thurgood Marshall is he said, stop it. We're going to argue principle. We're going to the court and saying separate but equal is deeply, profoundly, and absolutely wrong. And I'm not going to try and make a case that might have some pragmatic value to it. I'm going to the court to say, rely on the Constitution and do the right thing. The Loving case. This is the one that ended a ban, a state ban, that was one that was true in many states, on interracial marriage. I raise this one in some ways because I have a horse in this race. My wife is Caribbean, and we are a part of a kind of marriage that until Loving, believe it or not, was illegal in many states. And again, what the court said in a context where people often said, we're just fine with those state laws, is wrong. And we stand for something profoundly different than that, and we stand up against the majority so, and then I just would say this, so people like Cavenagh can flourish in his marriage. Obergefell, the most recent example, which is the Supreme Court's 14th Amendment case that says same-sex marriage is absolutely protected in all 50 states, and that all 50 states have to honor those marriage licenses one as to the other. Again, while there was probably a relatively stronger numerical majority in favor of this, it would be fair to say that for most of American history there was not, and it's the court that carved out that space. So I guess I want to argue this. A majority of Americans would have done exactly the opposite of what the court did. They would have deprived people of those rights, and I'd invite you to think about how much less room there is to flourish as human beings when we're told who we can and can't marry, and when we're told where and when we can go to school. So a couple quick words about the court's work this term. I just want to mention 3 cases and then close up. The first is a case called McCoy. It's a fascinating case that involves a Louisiana defendant charged with a triple murder. He was a difficult client with whom to work. His original lawyer quit. His parents hired another one. And that lawyer, recognizing that he faces the death penalty, says to him, I'd like, in a 2-phase trial, in all death penalty cases, there's a guilt and innocence phase and then a penalty phase. So if you're found guilty, you turn to the question of whether or not you get the death penalty. And McCoy's lawyer says to him, I want to save your life, and I know more about the law than you do. And the way I can save your life is to tell the jury you did it and not put them in a position where they've got to find you guilty, see you as unrepentant, and then sentence you to death. He objects vigorously. His lawyer repeatedly approaches him and says, I want this to be our trial strategy. And indeed, the lawyer went ahead and did it anyway. That is to say, went and told the jury, he did it. Now let's move on to the trial phase. Now I want to pause and say the lawyer didn't do this in bad faith. There's nothing in the record that suggests he was doing anything other than trying to save his client's life. That said, the court made this judgment. The Sixth Amendment gives you a right to a lawyer, and the Sixth Amendment gives you the right to own your defense, to make your own judgments, the liberty to make your own judgments. A second case from this year, Collins, just decided this week. This is a search and seizure case. It's a Fourth Amendment matter, and it involves a really interesting case. A guy is repeatedly seen driving around on a motorcycle at enormously high speeds. The police can't ever catch him. Literally, he gets away on the motorcycle. They track him down through Facebook. So I'm going to just suggest one of the good reasons not to be on social media. Here's this guy that got away with it, but for the police track him down on Facebook. They find the house at which he has parked this motorcycle, they think. They go to the house. They see in a carport, that is to say, a roof, no walls, driveway, what is evidently a motorcycle with a tarp pulled over the top of it. And what does police officer do? Well, I saw on Facebook. I think this is probably the guy. And right up the driveway goes the police officer, pulls the tarp aside, sees that it's the motorcycle, takes a photograph of the license plate, determines that it's stolen, goes back to his car, waits for the guy to come home, and arrests him on his front porch. Question: do you have a right to privacy in, and here's this great word, the curtilage around your house? Answer from the court: you do. That is to say, these places in which people have a human dignity interest in privacy, and this is a thing that's very different than the rest of the world. A human dignity interest in privacy, we're going to keep the police out of them unless they've got a warrant. Now, bear in mind, there's lots of exceptions to that rule. If there's exigent circumstances, the police can search. But there weren't here. The motorcycle's under a tarp. The guy's not on it. It's not going anywhere. So this is a really important, it seems to me, while the facts seem a little funny, it's a really important case. Do you want the police walking up your driveway without a warrant? I don't. Those who had my privacy seminar in the winter will know I don't want any of these sorts of intrusions on privacy. But again, what the court says is, here's an important right that people that have a sort of sense of dignity about them need. And we're going to stand up to a state police officer and lots of friend of the court briefs that said this is absolutely something that we should allow. Court says no. The last one, and I'll just mention it in passing and close because I think I'm a little over time, is Epic Systems, a private employment contract case. And it involves the question of whether or not a person can be compelled to sign an arbitration agreement that waives their right to a trial and that waives their right to a class action. And the answer from the court is you can. It's a big win for employers, but I'd argue at another level it's a relatively big win for people. That is, it lets you make judgments with your employer or with your employee, depending on which side you are, about how you're going to conduct your work lives with one another. So each of these three cases sort of continues this tradition. So let me just close by saying this. I think the most important vote you're going to cast in the next presidential election is for the one thing that's not on the ballot. That is the court. You're going to elect a president, and he or she is going to appoint, depends on how many, and when, but is going to appoint a Supreme Court justice. And that person is probably going to be more important than the person you elected because they're going to run the most Democratic branch. Thanks.